Welcome back to the No Say Project. I'm your host, Marc Stevens, author of Government Indicted. The website, of course, is markstevens.net. And I usually say on videos that we are live every Saturday from 4 to 7 Eastern Standard Time. We actually are live right now here on LRN.FM. And I'm going to, like I mentioned earlier, going to do a screen video of the... it just is garbage. That's the only way to really describe it. It's just loaded with false statements and logical fallacies. It's just, it's just bad. But it probably is the best that this attorney could do. And we'll have it here, under the success, under the, it'll be part of the show archive, and it'll be linked, and we'll also have it as one of the articles and videos. But it is just trash. So what she tries to do initially, this is the Whitman County prosecutor up there in Washington, near Idaho, I guess, and it's supposed to be her answer. She's saying here that no facts that prosecutor engaged in misconduct. Petitioner incorrectly asserts that the prosecutor engaged in misconduct because it did not prove jurisdiction. The judge ruled, you guys on the chat, it's going to make it tough, but I'm doing this a screen video, so, oh, damn. Well, anyway, all your chats are going to come up on the video, so there's not much I can do about that. So keep that in mind, so keep the profanity to a respectable level, guys. So the judge ruled on this issue during a motion to strike dismiss hearing on February 18, 2015. The relevant statute on jurisdiction is RCW, which states the district court shall have jurisdiction. And I'm not going to read the rest of that. You can see it in the videos. The misdemeanors and gross misdemeanors that the petitioners charged with were committed in Whitman County, so Whitman County's district court has jurisdiction over the petitioner. Well, let's get one thing straight here. The argument, the charge of prosecutorial misconduct is supported by a lot of facts that she vehemently and adamantly, and she does the same thing in this document, I'll go down and show you that, is insisting that the Constitution and laws of the plaintiff state of Washington apply to this man because he is physically in Washington. And she did not produce a single fact to support that argument. And she even states it here. She's not even doing it based on facts. It's clear. She says the judge ruled on it because the relevant statute. We know you're using the statute. We're saying that you don't have a shred of evidence and a competent witness to actually support your argument and prove it. Just going back to the code, well, the relevant statute on jurisdiction, we get it. We know. That's why you have to say to them, have I given you the impression I'm retarded? Oh, you don't think I'm retarded, but you're going to treat me that way by making such ridiculous statements. See, what it comes down to here is, one, she's lying, saying that when she basically no facts that the prosecutor engaged in misconduct. That's not true. She just disagrees with what was presented or is ignoring them. So coming out and claiming, she actually makes the case for me here. If the judge is basing his decision on jurisdiction strictly on the argument that the code applies because the code says so, that's circular logic. That's not facts. Going to the statute is not a fact. Claiming something, it's just nonsensical. They're saying the prosecution did prove jurisdiction at trial and a jury found such beyond a reasonable doubt. No. And she says here that the troopers, all with personal knowledge, testified under oath that the crimes Mr. So-and-so committed were in the state of Washington, County, or Whitman. Therefore, based on RCW, no. They're testifying that the law applied, but they don't have any actual facts to support that particular argument. So then we come down here. No facts that jury was unfair / impartial. Petitioner argues that since the jury pool believed the Constitution and RCW applied to him, they were unfair and impartial. It is true that now, bear with me here, everybody, because what she's doing is she's throwing in some political weasel words to try to make things, basically a red herring or actually a straw man, to make it a little less obvious how that she didn't have any actual facts. She says, it is true that during voir dire, some of the prospective jurors stated that people within the state of Washington are subject to the RCWs and Washington's Constitution. That's not what we said. The issue was, do you believe the Constitution and RCW apply to me just because I'm physically in Washington, not within the state? That's the plaintiff. It's not the physical ground. Because they all believe, the argument is, again, if you're physically in Washington, then the constitutional laws apply. So it is true that during voir dire, some of the prospective jurors stated that people within the state of Washington are subject to RCW and the Washington's Constitution. Petitioner incorrectly argues that an element of the crimes is whether the Constitution and Code applies to him. This is where, when you see the actual document, it has more of an impact. She then contradicts herself. There is no question that the RCWs apply to people within the state of Washington. And what she goes, see RCW, she quotes the code again. The code says it's applicable, therefore it is. That's circular. It's not evidence. The element that the prosecution had to prove was whether the petitioner was within the state of Washington when the misdemeanors occurred. The prosecution proved that beyond a reasonable doubt through the testimony of witnesses with personal first-hand knowledge. Petitioner has provided no facts or affidavits to show the jury was unfair or impartial. They admitted, she agrees, that they already believed an essential element of the crime and jurisdiction. You cannot prove that the code was violated unless you prove that it was applicable. But she's not doubting, she's not arguing that it's not applicable. She's saying there is no question they apply. There's no question? Of course there was a question. What facts and witnesses do you rely on to prove that just because he's physically in Washington, the Constitution and laws apply to him? She has nothing. All she could do is go back to the actual code itself and say, the code says it applies, therefore it does. That is not fact. You don't prove something beyond a reasonable doubt. You don't prove an argument beyond a reasonable doubt by giving another argument or giving a logical fallacy, which, of course, was pointed out. It's almost as if they think that people are so stupid they're not going to catch it, because the judge is going to allow her to continue getting away with it, which is what he has done so far, which is why the guy was in front of a jury to begin with. She knows that he's going to allow her to keep getting away with that. So, we got a bit more to get to. We got 2 more segments to cover this. My name is Marc Stevens. We'll be back here on the No State Project on LRN.FM in just a few moments, so don't go away. We've got a lot more logical fallacies to uncover. Welcome back to the No State Project, live from the fortified compound in Mesa, Arizona. It's March 14th, Pi Day, March 14th, 2015. Of course, the website's markstevens.net, where you can get a copy of Government Indicted, and I promise you, real soon, the ebook of Government Indicted will be available. So definitely look for that. And I know I've played fast and loose with the definition of soon. I'm talking within the next few weeks, so if not sooner. So, but to get back, what we're talking about here is some of the logical fallacies and the garbage that you will get from prosecutors. And what's different here is we usually don't get a response in writing because the judge is so compliant with them and prosecuting you, just like Troy, last caller had mentioned that they're trying the case from the bench, which is what they're doing. They're double teaming you, so they usually don't have to respond in writing and give us this garbage. They just stand mute. And for those who don't believe that, even Troy mentioned it. We've had other callers, and go to markstevens.net, look under the call of shame for Ian Freeman, which kudos to Ian for cutting that woman on that segment that they just played on Free Talk Live, which is, of course, immediately after the No Say Project here on LRN.FM. So check that out. I completely lost my... Oh, the Ian Freeman, the hearing that I did for him, I accused Gene Killam of prosecutorial misconduct throughout for almost basically over and over for almost an hour, and she didn't say a single word in her own defense. Why? Because the psychopath Michael King was covering her burden of proof. So you can check that out, and it's on video. So here we've I know she read the motion to vacate this ridiculous verdict and subsequent judgment from the psychopath Robinson. So because she lays it out, she addresses every single position that we've taken here. So number 3 was that no facts jury was not truthful. Petitioner argues that the jury was not truthful because they viewed acting as a juror a civic duty rather than coercion. Petitioner asked the jurors if they felt coerced, and they said no. Petitioner provided no facts or affidavits to show that the jurors were coerced or that coercion influenced the jury's verdict in any way. No facts to show the jurors were coerced? Well, if you look at the actual document, we point out that they were under subpoena. And I even quoted the RCW that made it a jailable offense not to comply. So the idea that this woman she's lying. Of course the facts were there because we pointed out they were under subpoena. She's not disputing that they were under subpoena. She knows they were under subpoena. So to say that no facts were presented, that they were there coerced, that their appearance was coerced, it's ridiculous. Of course they were coerced. Show up today or you go to jail. That's coercion. And hey, if you don't think saying to somebody, do this or I'm going to put you in a cage is coercion, wow. Are you selectively illiterate? Oh, that's what I remember. It's not threat, duress, and coercion when people call government do it. That's right. See what the CIA was doing? That wasn't anal rape. No. That was an enhanced interrogation. Yeah, that's right. Enhanced interrogation. So this is just flat out wrong. I mean, the woman is just lying. And had the coercion influenced the jury's verdict? They walked in the door already having him guilty of the single most important element of the charge. And that was that the code was applicable. They walked in the door with that. They were forced to do that. So, yeah. Let's move on to number 3. I think we're showing here that this attorney has no scruples whatsoever, will just lie and ignore the facts, which she did throughout the entire trial. Although I do have to say at this time I'm speculating that this attorney, this prosecutor that wrote this, or at least signed her name to it, was the trial attorney. I'm pretty certain. I believe she was, but I don't know. I have to confirm that with the client. Yeah, let's put client in quotes, since there are people that think client only refers to attorneys, that only attorneys have clients. I mean, that's, wow. So when it comes to coercion, it doesn't apply to them, and the word client does. They got a real funny way of using the English language. Okay, no facts that the judge impeached the witnesses or denied effective cross. Petitioners provided no facts that the judge impeached the witness. Really? The woman objected to a question of fact based on the argument that the witness could not give legal arguments or give legal conclusions. The judge sustained the objection for all 3 witnesses, which were police officers. on the grounds that the question called for a legal conclusion. This was brought up in the motion to vacate. Those were the judge's. The judge's actual statement was used, and she doesn't think that that's a statement of fact. What the ruling, which was in her favor, that it called for a legal conclusion. Now, if you ask her, now we go back, you can see. I'm going to go back here. She actually wrote in here that Washington state troopers, all with personal knowledge, testified under oath that the crimes were committed in the state of Washington. They testified that crimes were committed. That is not a statement of fact. That is a legal conclusion. And she objected on cross-examination when this man was questioning her own witnesses. She objected, and the judge sustained the objection that the witnesses could not give legal conclusions or give legal opinions. When you say someone violated the law, when you say somebody committed a crime, that is a legal opinion. It is not a statement of fact, and anyone who tells you different is lying to you or is grossly ignorant on basic principles of the legal system. When you go to court, or just when the cop is out on the street. A cop cannot do his job without making legal conclusions all day. He is looking at somebody and applying the law. He's saying, I have jurisdiction. I can invoke my force continuum now because the laws apply to him because he's physically here in Arizona. My force continuum kicks in if he does not do what I tell him to do. And that's why you have these cops that say, you don't want to be shot in the street, do what the cop says, because he's making legal determinations. And yet here the judge actually said for all three witnesses that they could not give legal opinions or legal conclusions. That is impeaching the witness, at least as far as giving legal conclusions, because he's not allowing them to testify to legal conclusions, which they've already done, which started the whole mess in the first place. Regarding effective cross, petitioners provided no facts. He was denied effective cross-examination of witnesses. No, you just admitted on the other page that I showed, you admitted that they testified he committed a crime, but he wasn't able to ask them questions that called for a legal conclusion because the witnesses weren't qualified to testify. So they allowed them to testify that he committed a crime, but they were not allowed to testify to give legal conclusions. That's a denial of effective cross-examination. He does not assert which witness he was denied effective cross to. All of them. Oh, it's ridiculous how these people get away with such nonsense. So we're going to talk later. Has no facts that Judge Robinson did not presume innocence or that he aided prosecution. This is a good one. You're not going to want to miss this. We'll be back in just a few moments here on the No State Project. Welcome back to the last segment of the No State Project. We're live for March 14th, 2015, as we are live most Saturdays from 4 to 7 Eastern Standard Time on the LRN, the Liberty Radio Network, LRN.FM. And going to finish this last segment. I can't believe we're already in the last segment, but we're getting back to this prosecutor's response. And it's quite something. She says here, no facts that Judge Robinson did not presume innocence or that he aided the prosecution. Petitioner argues that Judge Robinson is supposed to presume the following statement is not true. If petitioner is physically in Washington, then the laws of Washington apply to him. This assertion is entirely incorrect for multiple reasons. RCW states that the district court shall have jurisdiction. There is absolutely no reason why Judge Robinson should believe a statute is not true. Well, there's a few things going on up here. It's kind of a red herring here. The issue is that the court's jurisdiction is based on his physical location being in Washington, and that's what gives the court jurisdiction. It's called territorial jurisdiction, and that is based on the laws applying to you if you're in a certain physical area. Okay? Going to the RCW, that the district court shall have jurisdiction, is that the court has jurisdiction because, well, the laws apply because the laws say so. Circular logic, not evidence. It doesn't support the argument. this other thing is kind of a red herring. There's absolutely no reason why Judge Robinson should believe a statute is not true. Okay, who made that argument? He says it is his duty to apply the law as written, if it's applicable. So the red herring here is that no one made this argument. No one said that he shouldn't believe a statute's true or not true. The issue is, has the prosecution submitted facts to support the argument that the Constitution and laws, the RCW, apply to him just because he's physically in Washington? And the answer is not a single fact. In fact, from the document you can see, the only thing to support her argument that the Constitution and laws apply is quoting the RCW. The laws apply because they say so. So the judge, who is supposed to presume innocence, is supposed to presume that is supposed to presume innocence on every element of the alleged charge. Well, there is no code violation unless the code applies. So he has to presume that. I explain this, of course, in detail in Government Indicted. Jurisdiction is an element of the crime. He has to presume that there is not jurisdiction until the prosecution does, to the contrary, till he show it with facts. Facts. Is quoting the law that you're trying to apply to somebody a fact that it applies? No. It is then the prosecution's job to convince the jury, beyond a reasonable doubt, that the defendant did commit the crimes in the state. They have to prove that the laws actually apply. The prosecution did this through testimony of witnesses with firsthand knowledge. No, the police officers, which we know through pretrial discovery with the Brady request, the witnesses did not have personal knowledge that the code apply. In fact, they were not allowed to testify on cross-examination about it because they were declared incompetent, that they could not give legal conclusions. Again, to make a statement that the Constitution and laws apply to somebody because they're physically in Washington is a legal opinion which the judge ruled they could not do. And yes, they may not have actually said he committed a crime, which they did. We have it in their own document. So some may come out and say, well, what if he only testified to what he saw? The thing is, these police officers did a stop and an arrest. They were making legal determinations. The cross-examination is not limited to just what was said in court. If anyone tells you that, they're lying. I don't care if they're a law school professor. They're lying to you. Cross-examination, the witness is open up to collateral attack on their competency and credibility. And so it goes back to prior statements, things that were said at the stop. So if they weren't qualified to give legal determinations on cross-examination, well, that, it follows they weren't qualified to give them on the stop. And if I can't cross-examine him based on what he did at the stop to determine probable cause, to pull me over in the first place, that's a denial of cross-examination or effective cross-examination. Petitioner has provided no facts or affidavits to show Judge Robinson did not presume innocence or that he aided the prosecution. The fact that he insisted on nothing more than circular logic that there was jurisdiction proves he did not presume innocence. The fact that he allowed it to get to trial without a single fact supporting the prosecutor's argument shows he aided the prosecution. It does not get any simpler than that. It doesn't get any simpler than that at all. I mean, that's, my gosh, it's almost as if she wasn't at the trial or has no trial experience whatsoever. It's like they pulled a paralegal out to respond to this who just got out of high school and had just almost no idea on how these things actually work. It doesn't take a rocket surgeon to understand that quoting the statute is not evidence the Constitution applies to you, which she insists does. Imagine that. And this is not something that hasn't reared its ugly head before, these logical fallacies. I've actually had people claim that the U.S. Code or the state law was evidence that the Constitution applied. Don't even try to process that kind of stupidity. The Constitution is supposed to be the source of the law. Now the law is going to, we have this Constitution. It doesn't apply to anybody, so we better pass a law saying it does. Oh, my gosh. So the last one is no facts that the jury instructions were unfair. Really? The judge, and this goes back to here where you can see in the video, that Judge Robinson did not, there's no facts that he aided the prosecution. The prosecution is trying to prove he violated the code, which of course includes proving beyond a reasonable doubt that the code applies in the first place with facts and evidence, not a citation to the code itself. So the judge told the jury that the laws do apply. The jury already knew that. Well, they already believed that. But let's say that they didn't. The fact that they were coerced to be there by this judge on a threat of jail, which is also a threat of death, that if you don't comply, we got this here force continuum, we will kill you to get you into this jury box. But the fact that he's telling the jury these laws do apply, even though not a single witness testified with a single fact to prove that argument. The fact that he said that to the jury, what we know, that right there is unfair. What we know about obedience to authority, that 67 to 91% of the time, regular people will hurt somebody, a stranger, on the say-so of an authority figure. The judge forced them all to be there under threat of jail. And he's telling them these laws apply. It's absolutely an essential element. It's not that the prosecution is saying that they don't apply. They just don't have any damn evidence that they do. And now the judge is relieving them of that burden by just telling the jury that it does. I mean, it's no different than the judge saying, this man shot this person in the head. You have to believe, ladies and gentlemen of the jury, that he did shoot this person. You have to believe that. They're going to believe it. To think that when you have a 67 to 91% chance that someone's just going to listen to an authority figure somehow does not apply in a court. That's a level of ignorance that is mind-boggling to me. To say that the judge telling an essential element of the crime, giving an essential element of the crime for the prosecutor to the jury is not unfair. It's astounding. It's like, oh, I'm going to make up my own rules, and I'm going to make up certain rules, and they're going to apply to the prosecutor. And I want the judge to say that they do apply to the prosecutor. You don't think the prosecution is going to say, you can't just make, we had a prosecutor do this in Minnesota. You can't just make up your rules and just say that they apply to everybody. Unless you have sufficient automatons with guns to force compliance. If you have men that you can pay to get compliance, then you can make up rules because you'll have people who are willing to kill others in order to get compliance. Ay vey. So that's that. We'll have that up on the website hopefully today. Again, my name is Marc Stevens. If you disagree with what I presented today here, especially with what we've got here in the this nonsense from the prosecutor, please, we're live every Saturday from 4 to 7 Eastern Standard Time here on LRN.FM. Until next time, salud.